The government rests in the federal sex trafficking trial of disgraced real estate moguls Tal, Orrin, and Alone Alexander, who are facing a slew of federal charges relating to sex trafficking in the Southern District of New York. The government rested on Monday, March 2nd, and I'm going to take you through just some updates as to what's been going on inside the courtroom and how it got very, very dramatic over the judge and the jury charges. And if you're not familiar with how this works, after both sides present their case and before the jury goes into deliberations, they are read the quote charges by the judge. And what this does and why it's so important is that the judge goes through everything and explains to the jury what they will be deliberating on, what the government has to prove in order for them to find the brothers guilty, or, if they don't prove their case, innocent on certain charges. So I'm going to go through what got so dramatic and what the main arguments were. But first, I want to just discuss the fact that the prosecution last week on Friday moved to drop 2 counts against the brothers, count 6 and 7. My kids were here. They go 6, 7. Sorry. So this doesn't, I don't want to say this doesn't matter because they still face additional charges that are essentially up to life in prison if they are convicted. I believe there are 10 charges left, but these 2 charges, 6 and 7, they were standalone sex trafficking charges, not conspiracy charges. And the government says they dropped these because victim 4, these charges relate to victim 4 and 5. They said victim 4 didn't want to testify anymore because they were intimidated by one of the defense's investigators. So the prosecution wrote a letter to the judge. I actually wrote about it, and I will put this in the episode notes. But they wrote a letter to the judge saying that the defense, their private investigator, approached victim 4's neighbors and kind of lied about who they were and asked about the victim's minor children. This really spooked her, and she's like, I don't want to do this. And then she stopped responding to the government. As far as victim 5 goes, I'm not actually sure what happened there. There's not too much of an explanation. However, the defense said, Mark Agnifilo said this in a letter that I also detail. He said, we had issues with this one investigator that we resolved, and we also just parted ways with him after we didn't quite like something that he did, or we didn't understand something that he did. So Mark wasn't exactly admitting to this investigator's bad behavior or saying, yes, this happened and we are aware. He was kind of saying, yeah, we got a weird feeling from him. And again, I'm paraphrasing. So it was up to me to just sort of, disintegrate this partnership, part ways with him, we're good on that. So he acknowledged that they parted ways, but he also said that the defense submitted basically statements saying that the brothers had alibis for the dates of these alleged assaults that I believe happened in the Hamptons, and the brothers were apparently in Manhattan the days in question, or the dates in question. So at this point, obviously the judge had the final ruling over this, but it's kind of like, yeah, the charges are dropped because like the prosecution doesn't have witnesses for them, so they can't move forward. So yeah, there's that. Okay, so let's get into the charges and just sort of some of the main arguments that really seem to take center stage here, but just some issues that came up. The defense, and by the way, sorry, I'm going so fast, I feel like, but I hated this during the Diddy trial. I hated sitting there while each side, gave the judge their notes about the jury charges. I just found it to be so tedious because, that's what it is. And you'll see why. Number one here, the defense is repeatedly asking for very, very small wording changes. So, you've got this document that's like, hundreds of pages basically, and you've got to go through each section that each side wants changed. So we're going through, really tiny words. Like, for example, the defense wanted to change the word every to each. Just little things that they think will help their case and will sort of resonate with the jury a bit better. They also wanted to add many extra reminders about the government's burden of proof. They also wanted to remove certain credibility instructions. And Judge Valerie Caproni, she rejected most of the changes, saying that many were just stylistic changes. Like, she basically was like, you want me to change the word from happy to glad? And she just said, it's just unnecessary because the charge already covered most of these concepts multiple times. So, the defense really just wants to reiterate and hone in on the presumption of innocence, and that the burden is not on the defendants, it's on the government. So, sorry, I should turn my phone off for these videos. My goodness. So there was a very, very big fight over witnesses testifying under pseudonyms. Now, I would say this was one of the most intense exchanges. And basically, the government is just like, yeah, there's some victims testified under pseudonyms. We're protecting them. And there's nothing improper about them testifying under pseudonyms. And it shouldn't affect credibility. But Mark Agnifilo pushed back pretty hard, saying, of course, the fact that someone uses a pseudonym is relevant. The reputation of this person matters for credibility. So the person that is testifying under a pseudonym doesn't face the same reputational consequences. And he feels the defense should be able to argue that to a jury. So Judge Caproni sided with the government on this, and she just was like, is there, some kind of legal precedent here saying that pseudonym testimony makes someone less credible? Obviously, there isn't legal precedent or there's nothing stating that, someone testifying under a fake name wouldn't hold the same weight as someone who would. I do understand what the defense is saying, but I also understand why the witness would want to be protected here. So the judge basically was like, just put all of this in your summation. Like, just put this in your closing arguments. I'm keeping things the way they are. And I'm protecting these women. So the defense also wanted to add just stronger burden of proof language. So the government, again, as I mentioned, they have the sole burden of proof. The defendants, they have no burden to call any witnesses or really prove anything. They honestly could, and it's really shocking to some people, I feel like, that the defense could just sit there in court the entire time doing nothing if they wanted to. And, if you guys followed the Wade Wilson trial out of Florida, I actually just watched that documentary. It was so terrifying. He's actually, he's going to be put to death. I mean, they've appealed, but he killed 2 women, and it was a tough case. And I have not watched a trial before where the defense literally just waived the entire opening statement. He was just like, the attorney was just like, I'm going to waive and save it for later. Okay. So anyway, yes, Caproni, about the stronger burden of proof language, she was kind of not having it. She basically said, I say it 1,000 times throughout the charge. And the defense argued that it needed to appear specifically in the section about access to witnesses. The judge refused. Let me see. The defense also wanted witness immunity. And this is sort of like separate from the charges. Sorry, we're kind of going into the defense case. But this was Allen's attorney, specifically Howard Srebnick. There is a witness that they want to testify, and they do not want this guy to be in fear of getting prosecuted. And so the judge basically, said, I don't even know if I have authority to grant this guy immunity here. She suggested a briefing on it. And the defense acknowledged that the appellate courts have not authorized trial judges just to grant immunity. So she just said, preserve it for appeal. And the guy that they're talking about is a friend of the brothers. And he is reportedly from a very prominent family, has a prominent job. So yeah, we'll see what happens there. Oh, also, basically, this guy, he won't testify without immunity. And then there's also a major heated moment over just basically a charge that includes the standard language of, quote, the government is not on trial. These are Caproni's words, and the defense strongly objected. They argued, that basically the jury should be allowed to consider investigative failures. And then they cited a case, and she overruled the objection and said, we're keeping this language of, quote, the government is not on trial. What else? Yeah. So the defense with their case in chief, this was as of Monday. I was not in court today, and they did not indicate how long their case would go. So we don't know that just yet. We don't know the rebuttal witnesses they'll be calling. We're not sure yet. So I will keep everybody posted. I'm going to try to get over to court Friday, perhaps. I actually have to check to see if they weren't doing Fridays previously, but maybe they are now as we're getting closer. So I'll keep you guys posted for sure. I will put my most recent article in the episode notes, and I hope you guys found this helpful. Just with everything that's just so closed with these federal trials. I know it's so frustrating because everybody wants to know what's going on and there are no cameras. So anyway, I will be back later this week with another update. I'm Lauren Conlin. Thank you so much for watching, for listening. Please subscribe to Los Angeles Magazine videos. I'll see you guys